Welcome to What to Do When, a podcast from real lawyers with real perspective, where we explore a variety of legal issues and scenarios. Each week, we focus on a new topic and discuss what to do when and if any of these legal scenarios ever happen to you or a loved one. With over 40 years of combined legal experience, our hosts offer their unique perspectives and insights on a range of real-life legal situations.
Welcome back to What to Do When, a dummy's guide to the legal verse.
Scott, what's on the docket today?
We're going to talk about assault, particularly domestic assault.
Like assault and battery?
Yeah, assault and battery. I think maybe we should start there real quick. What's the difference, Jackie, between an assault and a battery?
Assault actually is the attempt or almost touching. Battery is the actual unwanted touching-ish.
Yeah, and assault usually deals with the fear. You know,
Yeah.
you're putting somebody in fear. You're assaulting them by your fear. So, but these are very, very, very important. We're seeing a tremendous uptick in domestic assaults. Now, domestic assaults deal with usually a husband and wife or brother and sister or somebody in the context of the home. So that's a really big deal. But we're seeing a tremendous uptick in those kind of cases coming through our office. And
Because they're connected to protective orders. And so if you haven't listened to the protective order podcast, go back and listen to that after you listen to this one because they tie in really closely. They're very, very connected.
Exactly. And, you know, I want to say a couple things about this off the top. Number one, remember, this is a misdemeanor. A domestic assault is a misdemeanor. There's lots of ways to walk through this, but it's a very serious crime because when you get charged with a domestic assault and if you're convicted, federal law kicks in and your gun rights and so many other things are affected by that. So this is a really, really big deal that most people kind of blow off and go, oh, you know, it's just a assault and battery. I don't really have any much to worry about. And really you do. And this is something you really need to get a lawyer involved pretty quickly.
And am I correct or incorrect that if there's a conviction of a domestic assault and battery, so on a family or household member, that a protective order is automatic? Or how does that work?
Actually, it's not automatic. A lot of times the law enforcement or the magistrate will do a temporary protective order, but it's not automatic at all. A lot of people believe that, but they're two separate things. If somebody wants a protective order, they have to apply for it separately, but they usually kind of run the same channel. And then you get in the problem of you have a civil case and the protective order and a criminal case, which I won't go through all that stuff today, but there's a distinction there, and you really got to understand the law, and you really have to have an attorney who understands this area of law. Luckily for us, I mean, I cut my teeth on assault and batteries in the city of Richmond. I would literally try thousands of domestic assaults in my career. So,
Well, but it's important you point out, though, that you need someone who knows what they're doing. Not just a criminal defense attorney will handle a protective order the same, because a protective order really deals with the family court, juvenile and domestic relations court, as well as the criminal aspect of it. And you said you didn't want to get into it, but I think it's important that, well, you've got the criminal side and you have the civil side. I have been in court trying to get a protective order for my client, expecting, well, we're just going to continue this until the criminal trial is done, and had other attorneys say, well, what do you mean? Why would I want to do that? And the short answer
is anything you say can and will be used against you in a court of law. So when you go in the civil side, you're not looking at jail time. So you may be a little more loose in your communication, or you may have a different strategy civilly than you do criminally. But that strategy used in civil court can backfire in the criminal court. For instance, in a civil context, it's okay to give your side of the story. In a criminal context, you may not want to give your side of the story and open yourself up, because they have to prove in the criminal context beyond a reasonable doubt. In the civil context, it's preponderance or clear and convincing. Sorry, I don't remember off the top
But
of my
once you testify in the civil side in defense of yourself, all of that testimony can then be used against you on the criminal side, where before you wouldn't have had anything to be used against you. Potentially it was a he said, she said. So now it's the other person said and you said, not or who to believe. It's you've already testified essentially potentially against yourself. So you need someone, and we keep saying that, but you do need someone who knows the difference and knows the strategy on how to tie those two kind of cases together, the assault and battery and the protective order. And when you're defending those, right, if Scott is representing the person who's been accused of the domestic violence and has protective order and criminal charges pending, that's one side of the case. And if I'm defending again, or if I'm trying to get a protective order against his client and I'm trying to make sure that these assault charges stick, it's just different strategy. And it's really important to have someone who's knowledgeable with both sides and certainly both aspects of the case.
Absolutely. I can't tell you how important it is and to know. And we see that when we see an attorney not know that, we cringe because we understand that he may be opening his client up to something that he didn't even realize. And quite frankly, when I started, very rarely were these two tied together, assault and battery and the protective order. But now they're almost more often than not. So, and you have to know, sometimes you're going to have to postpone the protective order to handle the criminal, which may mean you might have a protective order in place for a little while until you can get the criminal side done. And that's not okay, because if you have a protective order in place, again, gun rights and all kinds of other rights start to get affected. So you have to know that, but you have to play this game right. And sometimes you have to give up a little bit to get to a better end, and having an attorney advise you through that's very important. But the other thing I think is really important about saying about assault and battery is that, as Jackie said, I would say 90%, if not 98% of these cases are he said, she said.
Mm-hmm,
It's two people in a house, brother and sister, usually husband and wife, and
domestic partners of any kind.
Yeah, domestic partners of any kind, and nobody saw it but them.
Right. Exactly right.
And, and I always say this too, what people don't understand is assault, if Jackie doesn't want me to touch her, that's an assault. It's an unwanted touching. There's the old case law, and I always remember this in law school, where the guy was flying a kite and the person cut his string, and because he was attached to the string, it's an unwanted touching because you're touching something that somebody else is touching. So,
and I've had the case, I'm sure you have too, but I've had the case where somebody grabbed the cell phone out of the person's hand. Let's say Scott's holding my cell phone. I grab my cell phone out of his hand. That's a battery. Mm-hmm. That alone is enough. And I've seen protective orders issued for that. Anyway, it's just, you have to be very mindful of what it is. Any unwanted touching.
Yeah, and I really want to dig down on this just a hair, and I don't want to spend too much time on this, but a lot of times in a marital context, especially, hey, honey, are you listening to me? Grabbing her arm is totally been okay for 30 years, but when she's mad at you and you do it, all of a sudden you've committed an assault. And you really have to know that, and you really have to understand that in our current culture and where we are now, those things are happening all the time. So something that she may have done to you 5,000 times the same way. Honey, you need to listen to me. She may have pulled your chin. Hey, honey, you need to listen to me. And all of a sudden you do the same thing to her and you've just committed an assault. And you're like, hey, we've done that for years. That's not an assault. I mean, in battery. I should say assault and battery.
Right.
But it is. If it's an unwanted touching, it's an unwanted touching. Now, I just really think you have to know that and you have to understand that, especially in these domestic cases. And if you see that things are very contentious and situations getting bad, the best thing you can do is walk away. If you're going to remain in that situation, I always say this. One of the things I will do sometimes in situations where I think are sketchy is I put my phone in my pocket on record, leave the camera sticking out, and just on the camera. Well, I got the cord too. But I'm just on the case that maybe I'll have some evidence if something goes bad. If I walk into a bad situation, I've over the years, walked into maybe what I thought could be a bad situation. So I just have that instinct because I've been doing this so long.
Right.
But you've got to gain those instincts. If you are in a marriage that's breaking down, in a family situation that's breaking down, you have to guard against these kind of charges because they are serious and they have long-term impacts on your record. I mean, all of a sudden, you're a husband beater or a wife beater, and that may not be in your character at all, and you may never have done anything, and what you did was pretty minimal, like take Jackie's pen out of her hand. And we're dead serious about this. It seems silly, We get it. We understand it. But you've got to understand it. It's very important.
Can you touch a little bit on weapons? I don't mean, of course, jabbing a knife in somebody or using a weapon to pistol whip someone or shoot them, but how maybe holding a knife during a dispute could impact an assault and battery charge. And would it?
Well, it does, but sometimes there'll be another charge like brandishing a firearm or something like that. But really, it comes down to, again, it's a threat. The assault is a threat. So if I'm going like this and saying I'm going to hurt you, I've assaulted you.
But what if there's no act? And I have to be careful because we don't want to disclose too many details. But what if there's just there's no threat? There's just maybe you are
cutting potatoes.
Cutting potatoes.
Absolutely.
Sure.
Yeah, that happens a lot, honestly, and we see it a lot in our context where wife is cutting potatoes, angry at husband, but she's cutting potatoes. He's over here, they're in a fight, and he goes, "Oh, she threatened me with a knife." Did she really? But again, in these he said, she said contexts,
exactly,
that's not a threat. But unfortunately, sometimes these things get perceived as threats, or it's just a way to get the upper hand. And that's the most sad part about assault and battery and protective orders, are when I believe, because I really believe there's true victims out there who've really been injured and really been hurt and really need the protection of the court and really need the
absolutely
assault and battery. But when they're used, so often what we see is used as an upper hand, like in a divorce, because you position yourself, if you get an assault conviction and he can't have contact with you and you get to live in the house and have the cars and do anything you want, there's a lot of downplay to that. So, all of a sudden, even in the divorce context, that assault and battery can hurt you because, you assaulted her, you got convicted for assault. So it goes to fault grounds, all those things. So it's super important. And again, I think what we're trying to convey here is how simple, number one, it can be. Number one, an assault is a threat, a battery is a touching, an unwanted touching, and it doesn't matter whether you hurt them or not. I hear that all the time. It doesn't matter. I just assaulted Jackie.
Didn't hurt me at all.
If she did not want me to touch her. So that's really understanding that.
He battered me.
Yeah, battered. Yeah. I keep saying assaulted, but it's battered.
Yeah.
So, and most of the time you're charged with assault and battery together. That's just how Virginia does it.
I'm not sure. Are there separate? There might be separate code sections. I don't.
No, there isn't. But there is a separate civil battery and a civil assault. Okay. So that's where it comes from. But secondly, you have to know the environment in which you're in. And quite frankly, you can't always protect yourself. I can't believe how many times we've had made-up stories. But when you have he said, she said, and I say, Jackie punched me in the arm, that's an assault, but there's no proof of it, and I'm lying, it's really, really hard to disprove that.
Well, and in all fairness, we've also had clients who we know were battered, right? And who, I'll never forget, I had a client who's was very badly beaten. The next day she was pulling the ponytail holder out of her hair, and clumps of hair were coming because he had grabbed the ponytail and had been pulling on it. And sometimes you'll see when the blood vessels or capillaries in the eyes are ruptured because they've been strangled. Mm-hmm. You can't argue with that. You can. There are people who are gonna. What if she cut herself? What if she hit herself? What if she threw herself down the stairs to make it look like I did something? Sure, you're gonna have those, but. It's hard to strangle yourself enough to the point where you have broken blood vessels in your eyes, but we have seen the real situations where assault and battery has occurred and the protective order is necessary and charges are pending, and it's terrible. And we are also here for those domestic violence survivors and understand that we're really not focused on those issues so much as we are on what assault and battery really looks like and how you could find yourself in a situation where you're being charged.
Again, it's a criminal charge, and what we're trying to explain to you is in a criminal charge, again, that old adage we're going to say every time, do not talk to anybody until you've talked to a lawyer if you're charged, because what you say can and will be used against you, and most often when you think you're talking your way out of it, you're actually talking yourself into bigger trouble.
I didn't hurt her, for example.
Exactly. That's the number one I hear all the time. I touched her, but I didn't hurt her. We've been doing that for 20 years. I'm like, you just admitted to an assault. So really, if the police are called to your home, usually the best thing you can do is say nothing or I did nothing and leave it at that. and just don't say anything else.
You can say, I'd like to speak to my lawyer first. You don't have
Yeah.
to say a word other than, I'd like to talk to my lawyer. I'm not prepared to offer you a statement.
Yeah.
And what may happen if one side talks and the other side doesn't? What may happen to the side who doesn't talk?
You may get arrested. We always say that. You may get arrested, but it's worth it. Your statements usually don't help you. I mean, there are some brilliant people out there who are very good at talking their way out and have been very lucky over their life, but it always catches up with them at some point. So we suggest never talk, never try to talk your way out of it. Talk to us. You do not have to make a statement now or ever. And quite frankly, again, I say this all the time, but most crimes, the person's found guilty because of their own statements, not because of the evidence. Now, in these kind of assault and batteries, next thing I want to say, point number two is they are he said, she said cases. And that's a problem for me because I don't believe our law is set up to handle that and having a trier of fact. But quite frankly, the judge is going to pick one person, say he has more credibility than the other, and that's a very scary place to be. I've always believed it should be on the testimony of two or more witnesses, and the reason that is, and the reason that was our foundation of our law, is because you can't just make claims. And then the other side comes in real quick and says, oh, what about, they'll never catch this person. He always does it in his house and in quiet. And I get that, and we have the greatest empathy, and we'll help you if that's you. We'll help you get the evidence you need.
Sure.
And there's ways to capture evidence and all kinds of things, but the court shouldn't operate that way. But that's a whole nother story, but I won't get on my soapbox. But it's a he said, she said case most of the time, and they go by credibility of the evidence. So having details, knowing what happened, if you know that if the police are called, maybe you should sit down the next few minutes and write down exactly what happened. And so you keep it fresh in your mind, exactly where you were standing, what you were doing. All those details matter when you're defending yourself. When she says, oh, he was doing this, and well, actually I was over here, and she said he ran down the steps and pushed me into the door. Well, I never left my bedroom. I have proof of that because of this, this, and this, and this. Those can really be ways to vindicate yourself and get yourself out of a mess. Again, if you're in a contentious situation and you know things are going south, turn on your phone. If nothing else, record.
Right.
Audio record, video record if you can. But the bottom line is, don't put yourself in a position. In a heated argument, never touch the other person. It's just not worth it. I mean, you may have been doing that for 20 years. Honey, please listen to me.
Absolutely right.
I just suggest not to do it.
What about, Scott, when a parent, step-parent, future step-parent, maybe it's a fiance or a partner of some sort, lays hands on one of the children in the home? Now, I don't mean that we're wrestling and we're being fun, we're having fun, but pushes the kid or in some way, could the parent who's not present with this parent and the friend, partner, whatever it is, how does that work? So let me give you the scenario. Let's say you've got an 8-year-old, 10-year-old, a child of speaking age who's at least credible, could relay a story, and comes home and says, Dad, I was over at Mom's and her boyfriend was over and he slugged me in the arm, but there's not a bruise, but it really hurts, and he hit me because I backtalked Mom. Mm-hmm. As the parent who's hearing the story, are you able to relay that into an assault and battery charge? Is that assault and battery when there's a child involved? What does that look like?
It is. Unfortunately, it is. And not unfortunately, it is. When you batter somebody, it doesn't matter the context. It matters whether you had an unwanted touching. It doesn't matter if you're an adult, but obviously there's a provision for disciplining your child and all those kind of things, and that will have to be another podcast. That's something I'm very concerned about where we're going in society. But as a step parent, you have to be very careful. And quite frankly, we've had some cases over the years where it was wrestling and the kid just got mad because later he got in trouble about something else and used that wrestling match earlier in the day
right.
as a context or a pretext to get an assault charge. And a lot of times we can get through that, and usually kids eventually come clean with the truth. But, if a kid's mad at you, he can say all kinds of things, and it's not very helpful. So that's about all I wanted to cover today. I think we've covered everything. But, folks, we wanted to talk about, number one, the importance of domestic assault. If you're charged with domestic assault, number one, don't talk to anybody. You need to talk to a lawyer. We don't even suggest that you may want to talk to a lawyer. You need to talk to a lawyer. You need to talk to somebody who's good on the protective order side, divorce side, and the criminal law side because they're important if they're interacting together and how that works.
The context, number 2, the context of the battery rarely matters in domestic assault. It just rarely matters.
It rarely matters. And what she's saying again, that context of what was going on, what happened for years, doesn't matter. It's an unwanted touching. It's usually hearsay, and it's usually he said, she said.
And then the third point, the third takeaway?
I can't read your writing.
The heavy penalty.
Oh, the heavy penalty. Yeah, I'm sorry. I thought it said hearsay. But heavy penalty. Remember, domestic violence convictions affect a lot of your civil rights, your gun carrying rights, your rights to own a gun. That's a big one, obviously, but there are other things that it affects. And it also sets you up for problems in your future because once you're convicted, you always look like the bad guy, and that's a real big problem if you have some kind of contentious relationship.
And it can come up on employment applications
Absolutely.
As well. Not just have you ever been convicted of a misdemeanor, but have you ever been convicted of domestic assault? Very specifically, they can ask you that. And in another podcast, we can get into the consequences and how to handle it once you get to the trial stage and whatnot. That's definitely in another podcast when it comes to sentencing and the consequences of convictions. But for today, those are the takeaways.
Yeah, can I say one more thing? I think it's really important. I want to start adding this into our podcast. I've been thinking about this a lot. We never want you to believe that it's not, you never talk to the police. When you're a criminal defendant, you never talk to the police without talking to a lawyer. That's
right.
I'll stay with that mantra my whole life. But if Jackie's witnessing a crime, we're not saying don't go tell the police what happened.
Right.
We want you, we're the citizenry. We're part of that process, and we should speak up and we should speak out when we see things that are wrong.
Sure.
But what we're saying, I just wanted to be specific about that. When you're the person charged, do not talk.
Yes. Very good.
Thank you very much.
We hope you've enjoyed this episode of What to Do When. For more episodes, be sure to subscribe to our podcast, and we encourage you to check our archives to listen to previous topics. Tune in next week for a new episode and some fresh perspective from Critzer Cardani.